What's up, everybody? Welcome to this episode of Facts on the Ground. I'm Jesse Zerwell. I am going to be doing this short segment myself today, as my comrade Misty Winston is busy with family duties, but she'll be back soon enough, so don't fret. And I am very happy to be joined today by a former guest of the show and a friend of the show, Mohamed Elmaazi, who's been reporting extensively on the Julian Assange extradition quote unquote trial. And so we're just going to have a quick discussion today about what's been happening in that trial and the subsequent bail denial that happened this morning. So Mohammed is he's the editor of the Interregnum. He's a journalist who's written for the Canary UK, the Canary Global, the Gray Zone, Sputnik, and several other outlets. Mohammed, thanks for joining us today.
My pleasure.
Or joining me, I should say. I'm used to saying us.
That's right. It's the
So
Royals.
So on Monday, Judge Barry Itzer handed down a verdict, if you will, that Assange will not be extradited. And the main reason cited for that was because there is a high risk of suicide for Julian if he is extradited to the U.S. prison system. I think we both know there's much more to it than that. There's much more substance to it than that. Can you break down what that decision is and what's behind it?
Sure. So there were multiple grounds that the defense raised to argue against extradition of Julian Assange to the United States to face trial on 18 espionage-related charges, 17 of which are brought under the Espionage Act. The judge found against all of them except for one ground, which was that a combination of Julian Assange's mental state, the fact that he suffers from between moderate or mild to severe clinical depression. And it's important to note that the term mild depression in a clinical sense is not the way somebody might use in an everyday language, right? That mild, I'm mildly depressed. Somebody might say that that's not the same thing if you're diagnosed with mild depression in a clinical sense. And she found that a combination of that, along with what he would experience in United States in terms of pre-trial detention as well as post-trial detention, including solitary confinement and special administrative measures that would essentially cut him off from human contact for possibly years, maybe even decades. The judge felt that that created an insurmountable risk or too high a risk that Julian Assange would commit suicide. She believed that he was intelligent and clever enough, she said, to be able to circumvent any means. Anti-suicide prevention means she was not convinced that the states could guarantee that under those conditions that he'd be held, that he wouldn't commit suicide. But on all the other grounds, freedom of speech, freedom of the press, abuse of process, politically motivated prosecution, violation of attorney-client privilege as a result of illegal surveillance of Julian Assange in the embassy on behalf of the CIA. All those other grounds were dismissed. She found that that freedom of speech and the press is not absolute, that people can stop behaving as quote-unquote proper journalists if they engage in certain behavior. And that's quite crucial as well in term aspect of her decision, because there's so many aspects of what she wrote. It's a 132-page judgment, but I think there are certain aspects of it that are important to understand. Like one, she finds that okay, there's no public interest defense in the United States, as she was told and she accepted under the Espionage Act, but then there's no public interest defense under the Official Secrets Act here. There was in the 1911 version, the over 100 years ago. No, that was 99 years ago. But in 1989, the government removed the public interest defense after it had been used successfully. So there you go. There's you know, when you had objections to the severity of the Official Secrets Act when it was originally passed, and the government is compelled to put in a public interest defense, and then many years later, decades later, they just quietly remove it once they realize people can actually make use of that defense. And so she was unconvinced, or she saw no evidence that U.S. prosecutors are acting in any way other than good faith, no evidence that the Trump administration placed undue pressure to further the prosecution. And all of these do not bode well for journalism. So if you see anybody saying this is a great day for journalism, that's because they're not paying attention to the actual judgment. They're just seeing the end result. Extradition is denied. And they're not actually seeing the totality of the decision, which is effectively, but for his state of his health and the state of incarceration that he'd face in the United States, I would be extraditing him, essentially is what she's saying. She also was unconvinced that he'd be denied a fair trial because of the nature of the compilation of the jury. In the Eastern District of Virginia, there was an expert, a jury consultant from the United States, who broke down in detail. He says, look, for every single court and every division, you can see where the pool will come from. It can't just come from everywhere. It comes from certain constituencies, right? I don't know if you use that term in the States, constituencies.
Yeah.
Certain designated areas, legally, boundaried areas where people live. And he said, for this division, for this court, these are the constituencies. And then we can look and see who the main employers are there. And he went one by the other, went through every single area and said, okay, who's the top, 5, 6, 7 employers here? It's like CIA, FBI, Homeland Security, the US Pentagon. And then you have like Lockheed Martin or McDonnell Douglas or these other war contractors, weapons manufacturers, and associated, institutions, Booz Allen Hamilton, whoever, right? And then he goes to the next one, and then it's like Homeland Security at the top, FBI, CIA. So it just went on like that. It was just trading places in terms of. And her response was, well, I'm unconvinced. The argument was that the jury will almost certainly, if not definitively, come from either people who work for the national security state or who are related to people who work for there. And she's like, look, here's one constituency which has got like 1 million people. And then she moves on when she was describing her decision. It's like, okay, but that doesn't really say anything because millions of people work for like the national security state, right? So, of those 1 million people who live in that constituency, how many of them are children? Like how many? So that doesn't tell you anything, right? I mean, the fact that every other person who's been prosecuted in that court, the so-called Espionage Act court, right? Because it's the one they always choose specifically for that reason. That's why all espionage. You can charge somebody. So these are federal charges. You can charge them anywhere. Why are people continuously charged in that division, in that court, in the Eastern District of Virginia? And it's because of the compilation of the jury. So it's either willful blindness in my mind of jury selection, right, process, because you can't do that here. In England, there's no voir diring of the jury. Like there's a form you have to fill, like do you know about the case? Are you related to anybody? Question and answer. But that's it. You're not allowed to speak. You're not allowed to question jury members beforehand in this country. You're not even allowed to approach them after. If they decide to go to the press to tell them something, they're allowed to do that. But if a member of the press goes to speak to a jury, like, why did you make the decision that you did? They could be arrested for that, right? So the jury's meant to be. So it's whatever. The point is, this was her decision, except on the health grounds. So now do you have any questions, or shall we move to the bail part of it?
Well, I just want to follow up on that real quick. Do you think she's making the decision herself, or that there are other Western entities behind her who are pushing the decisions she's making. And also, you mentioned that we shouldn't treat this as a victory because essentially, as you said, it's just that extradition was denied. But at the same time, he's essentially being painted as Julian's essentially being painted as mentally unstable. And I feel like that's something that can be used against him in any future proceedings. Can you speak to those 2 points?
Sure. So I would say it is a victory, but it's a partial victory. So it's a victory for Assange, but not for journalism or free press or the right to receive and impart information or the right to reveal waste, fraud, abuse, criminality, corruption. So it's definitely a victory for him because historically, successfully appealing a decision that someone should not be extradited on health grounds has not been successful. So he has a strong he's in a strong position there, it would appear.
You froze. You still there?
Result of his
Hey, sorry, it froze for about 30 seconds, 20, 30 seconds there. So I didn't get what you just said.
okay. Where should I start up from again?
So you were talking about how it's not something we should look at as a victory, and uh, yeah,
Did I
I think just
mention
take
the
it from
fact that it's
there.
partial victory? Okay.
Yeah, sure.
So it is a victory. It's a partial victory. It's a victory for Julian Assange, but not a victory for journalism or freedom of speech or the right to receive or impart information. Um, there is the fact that historically, cases where accused suspects or defendants have have had their extradition denied on the basis of health grounds, rarely, if ever, have had that refusal then reversed upon appeal. So that tends to be a very strong basis to refuse extradition and to be comfortable in that fact at least. And my conferring with various legal experts seems to suggest that, or confirm that rather, that there's a very strong case at least to keep him here and to ultimately result, however the appeals go, in his favor. Now, in relation to whether or not it could be used against him, I'm not quite sure how that could be used against him. I mean, without wanting to speculate, I suppose if you have a family split up and there's child custody issues, then maybe that could be uh, raised, right? Possibly
Well,
legitimately. But in terms of the state itself, bear in mind it's the defense that raised these arguments. It's the
mhm,
defense that raised the fact that he's a high suicide risk.
right.
There were defense experts that presented.
And we're frozen again. Just a moment. Mo, can you hear me? Mo?